Some kind of box band and whatnot now. And neighbors are probably just accustomed to.
Pretty busy right now, Brian.
You know, the little contractor companies going.
Pretty busy.
Oh, just in general?
Yeah. Sure. Yeah.
That's what happens when you live
Oh,
out.
so they're just going down.
All right. 75th District Court is back in session. The Honorable Michael B. Carpenter presiding.
Thank you, everyone. Please be seated. Back on the record, the people of the state of Michigan versus Jawan Curry. This is file 20-1125 SM. Counsel, identify yourself for the record.
Thank you, Patrick Swinsky for the people.
Good morning, Your Honor. Brian Jean for the defendant.
May I ask your client's preference as to how much of his name he'd like me to say each time? Is it okay if I ask? Are you okay with Jawan, or would you like your middle name as well?
No, you just say the first and last.
First and last name's good? Okay. Just wanted to check. Sometimes people feel like they prefer just one or the other. Any issues before we bring the jury back? Mr. Swinsky?
No, Your Honor.
Any issues, Mr. Jean?
No, Your Honor.
All right, please rise for the jury. Thank you. You may be seated. Looks like everyone's got their juror button, their pen and paper in hand, and they followed protocol to get to the right seats. So welcome back. We're going to do some instructions, and then we'll do the opening statements, and we'll see how far we go before we take our noon break. Now I will explain some of the legal principles that you will need to know and the procedure we will follow in this trial. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes his, or he may wait to make it until later. These statements are not evidence. They are only meant to help you understand how each side views the case. To prove the charge, the prosecutor must prove the following beyond a reasonable doubt. First, that the defendant assaulted and battered Katoria Crawford. A battery is the forceful, violent, or offensive touching of a person or something closely connected with him or her. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Katoria Crawford's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have either intended to commit a battery or to make Katoria Crawford reasonably fear an immediate battery. In other words, an assault cannot happen by accident. At the time of the assault, the defendant must have had the ability to commit a battery, or must have appeared to have the ability, or must have thought he had the ability. Second, that at the time, Katoria Crawford was a resident or former resident of the same household as the defendant, or was a person with whom the defendant had or previously had a dating relationship. A dating relationship means frequent intimate association primarily characterized by the expectation of affectional involvement. It does not include a casual relationship or an ordinary fraternization between two individuals in a business or social context. Third, that the assault caused a serious or aggravated injury. A serious or aggravated injury is a physical injury that requires immediate medical treatment or that causes disfigurement, impairment of health, or impairment of the part of the body. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor's presented all his evidence, the defendant's attorney may also offer evidence. but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. This instruction says something that I'm not doing, so I'll explain. You have been given a written copy of the instructions I've just read to you. You may refer to them during the trial. Since no one can predict the course of the trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you a copy of the final instructions for use during deliberations. I choose not to give you copies during the portion of the trial because it is true the instructions could change and it makes no sense to gather them back and distribute them to you. So you do not have copies. You will have copies at the end. The final instructions you will have copies of, and you'll be able to take them into the jury room with you. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of this case. As jurors, you are the only ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted into the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you have based on race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but may help you think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was there anything else going on that may have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how does the witness testimony seem when you think about all the other evidence in the case? The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some questions to the witnesses myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts of this case. You are allowed to ask such questions. You should wait to ask your questions until the witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write down the question, and pass it to the bailiff, who is going to be doing that job this morning. You're gonna pass it to Deb, Miss Jason, and who then will give it to me. Do not show your question to the other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about the answer might have been given. Also, in considering the evidence, you should not give greater weight to the testimony merely because it was given in answer to questions submitted by members of the jury. On the other hand, if you cannot hear what a witness or lawyer says, raise your hand immediately and ask to have the answer or question repeated. So the difference is, if you have a question, write it down. If you can't hear, you must stop and let us know. During the trial, the lawyers may object to certain questions or statements made by the other lawyer or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other is not meant to reflect my opinions about the facts of this case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you're in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss this case with anyone, including your family or friends. You must not even discuss it with other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. When the trial is over, you may, if you wish, discuss the case with anyone. If I call for a recess during the trial, I will either send you back to the jury room or allow you to leave the courtroom on your own and go about your business. But you must not discuss the case with anyone or let anyone discuss it with you or in your presence. If someone tries to do that, tell him or her to stop and explain that as a juror, you are not allowed to discuss the case. If he or she continues, leave and report the incident to me as soon as you return to court. It would not be to me, it would be to Miss Jason. You must not talk to the defendant, the lawyers, or the witnesses about anything at all, even if it has nothing to do with the case. It is very important that you only get information about the case in court when you are acting as the jury and when the defendant, the lawyers, and I are all here. The restrictions I'm about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Now that many jurors have easy access to information through handheld devices and other technology, jurors may be tempted to use the devices to learn more about some aspect of the case. But if a juror were to do this, it would harm the parties. The party's attorney would have no way of knowing that a juror has gotten outside information and would have no chance to object if that information was false, untrustworthy, or irrelevant. Remember, no matter how careful and conscientious news reporters, family members, friends, and other people outside the courtroom may be, information about the case from television, radio, the internet, and social media will inevitably be incomplete and could be incorrect. Please bear these things in mind as I read the following instructions. These restrictions apply from this moment until I discharge you from jury service. You must decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that during the trial, you must not read, watch, or listen to news reports about the case, whether in newspapers, on television, on radio, or on the internet. You must also not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search on the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, computer, cellular phones, or other electronic devices. You must not visit the scene or any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you may have of the scene. Before your deliberations, you must not discuss this case with anyone, even your fellow jurors. After you begin deliberations, you should discuss this case with your fellow jurors, but you still must not discuss this case with anyone else until I discharge you from jury service. Until I have discharged you from jury service, you must not share any information about the case by any means, including cellular phones or social media. If you discover that a juror has violated my instructions, report it to my bailiff. Again, Miss Jason. You may take notes during the trial if you wish, but of course you do not have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during the deliberations. You must turn them over to the bailiff during recess. We just have you leave them in that jury room there. No one will get into them there. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. Possible penalty should not influence your decision if it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial, and at the end of the trial, I will give you detailed instructions about the law in this case. You should consider all my instructions as connected series. Taken all together, they are the law you must follow. After all the evidence has been presented and the lawyers have given their arguments, I will give you detailed instructions about the rules of law that apply to this case. Then you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. Mr. Swinski, that concludes the preliminary instructions. Is there anything you wish to place on the record before we go to opening statements?
No, I'm prepared to make another statement, Your Honor.
All right, Mr. Jean, any objection to the preliminary instructions?
No, Your Honor.
Any additional ones we needed to include?
No.
All right. Please turn your attention to Mr. Shawinski, who will give his opening statement.
Thank you. First of all, thank you for your patience this morning going through audio. I think what you're about to see is something you're more used to seeing, on TV or that type of thing. Lawyers up making arguments, not making a jury. But I appreciate your attentiveness this morning. You answered all the questions. What aren't always easy questions to answer, so I appreciate that. I'm sure you've gathered already, but we're here today obviously for a charge of aggravated domestic violence. And I'll go into a little bit of what I expect the evidence to be today. It's my job, I've talked about this already, but it's my job to present evidence, which is generally in the form of testimony from witnesses, possibly some exhibits, that type of thing. And it's my job to establish what are called elements of a crime. And I'll talk about them in just a little bit. I have to establish those beyond a reasonable doubt. And it's important, obviously, that you give great attention to the testimony and you view everything together. I'll be presenting a couple different witnesses, and this happened somewhere approximately almost a year ago. So you may see some instances where maybe some people don't remember some things. Unfortunately, we've had a little bit of a delay as to when we've been able to conduct jury trials, so this is a little bit delayed. So specifically, this happened back in August of 2020, so it's been almost a year. August 19th, 2020, it happened on East Grove Street, which if you don't know, it's just a couple blocks north of Dow Diamond. Right here in the city, here in Midland County. And in particular, it's been alleged, and I expect to prove beyond a reasonable doubt, that Mr. Curry, Mr. Juwan Curry, assaulted his girlfriend or former girlfriend at the time, Katoria Crawford, and that they were in a dating relationship or had been in a dating relationship at some point up to that time. And so that establishes what I'll call a domestic relationship, and I'll get to that in just a minute. And this type of assault happened. Katoria came home from work, and I expect that you'll hear all this during the trial today. She came home from work sometime during the evening. Mr. Curry was waiting for her at her home on the stairs leading up into her apartment. And apparently the relationship may have not been in the best state at that point. Katoria just wanted to go inside and kind of not deal with it. And Mr. Curry took her by the hair, grabbed her by the hair, pulled her down the steps, causing her to fall down and hitting her head. He then, and I expect the testimony will show today, that he then kicked her in the side and again picked her up to stand her up and tried to drag her back inside the house. At which point, I believe the testimony will show he became distracted, possibly by his phone ringing or something to that effect, and Ms. Crawford was able to get inside. She didn't call the police. She got inside, she was safe, but she decided not to call the police. Remember, they were in a dating relationship. She decided instead she was going to go to the hospital instead. So she went to the hospital without calling the police to get treated for some injuries. that she sustained as a result of the assault. While at the hospital, Officer Hager just happened to be there on a different, totally unrelated complaint. And he then took a statement from her and investigated the incident. Now, as I talked about, there's certain criminal elements I have to establish, people have to establish. There's basically 3 elements in this case. Number 1, there's an assault or battery. And essentially what a battery is it's an offensive touching. And the judge has already instructed you on this, and he'll instruct you on this again later. It's an offensive touching, or a touching that you don't want. And an assault is an action that causes someone to become in fear that they may be battered. So very commonly these occur at the same time. So you can commit both an assault and a battery at the same time. And that's one of the elements that you'll have to be exploring today. So I have to prove that, number 1, that an assault occurred. Number 2, that the relationship between Mr. Curry and the victim was one of a domestic relation. That can be established in a lot of different ways. For example, if the parties are married, if they used to be married, if they have a child in common, as well. In this case, what will come up is that they were in a dating relationship at the time, or they had been in a dating relationship in the past. That is sufficient to establish that relationship as well. And then finally, third, because it's an aggravated domestic assault, it requires that there be some type of injury that required immediate treatment. As I already talked about, Mr. Hager, Officer Hager, encountered Katoria at the hospital that day. She had gone to the hospital for treatment. And so that's what I expect the evidence will present today. We'll come out and establish those 3 elements. So those are the elements you're going to want to look at as we go through the testimony. Assault, relationship, injury. Now, as I said, this happened close to a year ago at this point. And as I'm sure everyone knows, memories fade. So there may be some situations where a witness doesn't remember something. I don't think that would be particularly unusual in a case like this. In addition, remember that it's a domestic relation. These two, Mr. Curry and Katoria, had a relationship. They were in love. And that may change, as we talked about in voir dire, that may change how she reacts. She might not react in a way that you would think would be typical to someone who's been assaulted. So you may see that as well today. But I am confident that at the close of the proofs and argument, that I will have established those 3 elements beyond a reasonable doubt, at which point I'll ask you during your deliberations to render a verdict of guilty. But for now, we haven't gotten to the evidence, so I'm going to stop my statement here so we can start to get into the real flesh of the case, the evidence, the witnesses, and any of the exhibits. So thank you.
I want to remind the jury that the defendant does not have to do anything. However, they can. Mr. Jean, have you made a decision regarding an opening statement?
Yes, if I can.
Would you like to give one?
Yes, please.
Please turn your attention, Mr. Jean.
Thank you. Good morning. I'll try to keep this brief, although the judge probably already knows that it likely won't be, because I have a tendency to do that. Obviously, first off, thank you for giving us your attention. I know that this isn't exactly what you'd rather be doing today, but it is very, very important that you continue to pay attention to everything that goes on. It's really, really important for Juan, and frankly, it's kind of important for you as well, because this is really kind of the basis of our democracy. This is like what gives the citizens like the most power. I mean, you have an incredible responsibility by being a juror, and frankly, an incredible power as well. So as Mr. Chwinski has already indicated, the idea of opening statement is to kind of give this roadmap of what each side expects. Obviously, as the judge also has indicated to you, our statements for this are not meant to be evidence. And frankly, I think one of the interesting parts about a case like this, I think it's going to be pretty short. I think the testimony is not going to be all that long, probably an hour or 2 of testimony is my guess. So shouldn't be too terrible. But the interesting part about a case like this is I think that you are going to probably hear these stories about what did or didn't happen. And you're going to be able to see that there's a bunch of holes in the story. So that's the thing that we want you to pay attention to. So Mr. Chwinski told you what he believes the evidence is going to show, that Katoria Crawford showed up back at her apartment, just not terribly far from here at, I think it's about 8:45 or so in the evening on August 19th, 2020. And when she arrived, that my client, Juan Curry, was there. And that this assault happened, pulled her hair, went up to the door, threw her down. So what I want you to do is I want you to remember those elements, those things that Mr. Schwinski told you. It's his responsibility to prove to you beyond a reasonable doubt that the assault happened. Has to prove that to you. But I also want you to pay attention to something else. And I think it's very important because it is not just that an assault occurred. Okay? Mr. Schwinski also has two other things that he must prove to you beyond a reasonable doubt. And it's very important because it is not just that he shows the one or two elements, it has to be all elements. And each must be proven beyond a reasonable doubt. What that means is that if you find that one of the elements has reasonable doubt, but the other ones don't, you still have to find Juan not guilty. Why we talked about it in voir dire, that I said, even if your gut says something different, I still need you to be able to go back and render a not guilty verdict on that basis. Now, maybe you're already ahead of me, but the reason that I'm bringing it up is because the other element that must be proven beyond a reasonable doubt is the injury. Without serious injury, it's not just an injury, you're going to get a jury instruction on it, it's a serious injury. I believe what you're going to hear by way of element 3 for aggravated domestic assault. The assault caused a serious or aggravated injury. A serious or aggravated injury is a physical injury that requires immediate medical treatment or that causes disfigurement, impairment of health, or impairment of a part of the body. That must also be proven beyond a reasonable doubt. Now, you have to make the decision as to whether or not those things are met, as whether or not what you hear is that there was disfigurement, impairment of health, or impairment of part of the body. I would argue to you at the end, I think, more fully on that in terms of what you hear. But keep those things in mind because those are very important things. Although I think you'll hear some other things about what happened that night, or frankly, what didn't happen that night. I also want you to pay attention to the background, right? I think it's very important with a case like this. It's, as lawyers, a lot of times we'll harp on, you got to focus on this issue, right? This one issue of what happened this particular night. And you do have to make your determination as to whether or not this particular thing happened. You shouldn't be basing your decision on whether or not something else happened 2 months prior or an hour before or something happened after. It has to be your decision on this one instance. That being said, I think it's a really good thing to know the background, to know what happened prior. Why is this case here today? And I think that what you're going to find is that during testimony, you'll find that Victoria is an angry ex that maybe she was cheated on, wants him back. So I think that you're going to find that there's probably some rationale as to why Victoria wants this to happen, or maybe doesn't want this to happen. So one of the big issues, again, is with a case like this, there's a lot of different moving parts. And so there's a lot of background that goes into these. So I want you to pay kind of close attention to some of those things to help you make a determination as to how things actually happened or didn't happen, as the case may be. So we believe that based on the things that you are going to hear during the course of this case, that there will be multiple things that you can have reasonable doubts on. But again, we want you to pay attention to those particular issues that I've talked about. And when it comes to rendering a verdict, we believe that you'll be able to find those multiple things that have reasonable doubts. But even if you only find one, again, please just bear in mind, just one, even if your gut tells you one thing, something different, just that one can cause you to have to render that not guilty verdict. So we certainly believe that that's what's going to happen at the end of this case. And again, I thank you for your attention and your service today.
Thank you. Mr. Swinsky, you ready to call your first witness?
Yes, Your Honor, I'll call Victoria Crawford.
All right, bring her in. Ms. Crawford, if you come right on up here, please. If you'd stand right here next to the podium. Raise your right hand and be sworn in.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you.
All right, watch your step around the ramp.
Your Honor, if she could please repeat that, it didn't come across.
Do you swear to tell truth, whole truth, nothing but the truth, so help you God?
Yes.
Could you hear that time, Trina?
Yes, Your Honor.
Have a seat, please. You're a witness.
Thank you. Good morning.
You have to speak a little louder, please.
Good morning.
Yeah, I have a feeling you're going to be reminded to speak up, so just try to keep that in mind, okay? All right, can you state your name for the record, please?
Katoria Crawford.
I'm gonna have you spell your both first and last name.
Katoria, Katoria Crawford, CRAWFRD.
Okay. And you're familiar with Joanne Curry?
Mm-hmm.
Is that a yes?
I mean, yes.
Yeah. Remember, it's yes or no. Can't say. We just have to make sure we have a clear record, okay?
Okay.
And Mr. Curry, he's sitting in the courtroom currently.
Yes.
Can you point him out for me? He's wearing the white shirt.
And yeah.
Okay.
Yes.
Thank you, Your Honor. And the record reflect the witness has identified the defendant.
Mr. Jean, any board your objection?
None, Your Honor.
The witness has identified the defendant.
All right. Now, Katoria, were you in a relationship with Mr. Curry at some point?
Yes.
Okay. What kind of a dating relationship?
Yes.
Did he ever live with you?
No.
He never lived with you?
No.
But you were in a dating relationship, boyfriend and girlfriend, essentially.
Yes.
Okay. Are you still in a dating relationship with Mr. Curry?
No.
Is it complicated?
It's complicated.
Okay. It's fair to say. All right. And you live here in Midland, right?
Yes.
You live up on Grove Street?
Yes.
Okay. Now, I'm going to take you back to August of last year, which I know is a long time ago. You were living on Grove Street at that point?
Yes.
Okay. And you were employed at the time?
Yes.
I think you're still employed, is that right?
Yes.
Okay. Sometimes you work longer type hours?
Yes, sometimes. It depends on the day.
Okay. Do you recall back in August of last year, August 19th, you recall going to the hospital?
Yes.
All right. And was that as a result of an assault?
Yes.
Okay. Can you tell me what happened?
Got into an argument.
Well, let me be a little more specific. You came home from work in the evening.
Oh, okay. So you want me to start from?
Yeah.
Okay. I came home and Joanne was there, and we got into an argument. We started fighting.
Okay. And where were you physically located at that point?
It started outside and then it went into the dining room.
Okay.
We just started arguing about cheating, of course, and it escalated. And it ended up us putting our hands on each other.
All right. Can you just be a little more specific about that? What did he? So he was there waiting for you, correct?
Yes.
Where was he located when he was waiting for you?
He wasn't sitting on the porch. He was in the car, I believe.
This was a while ago, right?
Yeah, I can't really remember everything.
Okay. But he was waiting there for you.
Yes.
All right. And he put his hands on you?
Yes. Well, I put my hands on him too, but yes.
Okay. And did you fall down at some point?
Yes.
Okay.
But I fell and hit my head.
Was that outside or inside?
Inside. It
All
wasn't
right.
outside. It was inside. I think that's.
Was there ever a situation where you may have grabbed your hair?
Yeah, but that's part of us fighting each other. So,
That's a regular
course,
thing that he grabbed
yeah.
your hair?
well, it probably only happened twice.
Okay. Is that what caused you to fall down?
Probably yes. Then again, I'm not sure.
Sure. It was a long time ago.
Yeah, it's almost a year ago, so my memory is not as good as back then.
So you and Joanne got into some type of physical altercation.
Yes,
You both were putting your hands on one another.
yes,
And at some point you fell down, hit your head.
yes. I just think he was just a little bit stronger than me, of course. But
Okay. How did the incident end?
him leaving,
So he just decided to leave.
yeah. After I asked him to leave.
Okay. And he did.
Yeah.
And then what'd you do after that?
We went to the hospital.
Was that because you had sustained some type of injury?
I was in a lot of pain from him fighting me, basically, for us fighting, fist fighting.
Okay.
So
you went to the hospital immediately after that.
probably like a couple hours after, once I couldn't do the pain anymore.
All right. So you had so much pain from the incident that you couldn't deal with it. You had to go to the hospital.
Yes.
So you needed treatment, essentially.
Yeah, just some pain meds, I guess.
Yeah. How'd you get to the hospital?
I can't.
Can't remember.
I don't know if the ambulance came or if I called to someone to take me.
Okay. Could you have called the cab, maybe? Maybe.
Probably.
Okay. At the hospital, what did the hospital staff do for you?
They took some blood work. Took pictures of the marks on my body. Gave me pain meds. Can't remember. They took my statement.
Was that the hospital staff or someone from the police?
Probably both.
Okay. That's fair. Did you ever call the police?
Yes.
You
Well,
did?
I didn't call the police. They asked me while I was at the hospital, did I want make a report?
Okay.
And I told them yes.
And then an officer came and saw you at the hospital, right?
Yes.
But for at least those couple hours before you went there, you didn't call the police.
Not that I can recall, no.
What led to that decision?
To not call the police.
Yeah.
It just wasn't really that serious.
You said And you had already testified that this happened before?
No, this was actually the first time.
All right, but you've gotten into some arguments before. I mean, what was your relationship like at the time?
It was just rocky, just because of the cheating. It was rocky.
And that's what led to this physical altercation.
Yes.
So you felt that it wasn't, even though you had kind of fallen down, you got some injuries, had to go to the hospital, you didn't feel like it was serious enough, at least at that point, to contact the police.
Nope.
Once you got to the hospital, changed your mind?
Once I got to the hospital, the doctors wanted me to make a report.
Okay.
So that's why the police was called.
I see. So the doctors convinced you that it was, okay.
Hmm.
That makes sense. Okay, I'm gonna go back to the incident itself.
Okay.
You ended up getting some bruises on you, is that fair?
Yes.
Do you recall where they were located?
Just probably one of them, not all of them. Like somewhere on my chest. I'm not sure where, but somewhere on my chest.
So did he grab you on your chest at some point?
No, probably just pushed me.
All right.
Not grabbed, just probably pushed.
And you don't recall any of the other bruises?
Not that I can remember.
If I showed you some pictures, do you think that would have refreshed your memory perhaps?
Yeah.
Okay. May I approach the witness, Your Honor?
You may.
I've already seen the pictures as well, so.
Okay, thank you. Do we have an exhibit number?
Yes, this would be exhibit 1 through 3. I'm going to start with. All right, Attorney, I'm showing you what's marked as plaintiff's exhibit number 1.
That's my chest.
That's your chest.
Okay, I remember that one.
Yeah, and this is one of your tattoos, right?
Yeah.
So I'm going to turn it around. I think this is the correct orientation, right?
Yes.
So actually upside down from the label on there. And you see, is that like a bruise on you?
Mm-hmm. Yes.
Okay. And is this what it looked like on that day? As far as you know?
Yes.
Okay. It looks like you're wearing a hospital gown there too. Is that right?
Yes.
All right. I'm going to show you what's marked as plaintiff's exhibit number 2. Do you recognize that?
Yes, probably just from him grabbing my arms.
Okay. But
yeah, it's a bruise.
a bruise, yeah.
Mhm.
Okay. And this is obviously your arm. You got a tattoo here. I'm assuming that's the same tattoo as.
Yes.
I assume you probably know what tattoos you have.
Yes.
All right. Yeah. Okay, and I'm going to show you plaintiff's exhibit number 3. Do you recognize that one?
Where is that one at? What was that? Is that my side?
I'm not sure. That was looks like a bruise. Looks like the same hospital gown.
Right. Okay.
The police took a number of pictures of you that day.
Yes.
All right, we'll come back to number 3.
Okay.
But number 1 and number 2, do you agree that was a fair representation of how you appeared that day?
Yes.
I'm going to move for their admission, Your Honor. Number 1, number 2.
Any objection or void for 1 or 2?
No, Your Honor.
Exhibits 1 and 2 are now part of the record.
And I would publish them with permission of the court.
Ladies and gentlemen, we have certain terms in the law. Publish just means show. So I am allowing them to publish. Please still listen to the testimony. When you're done, at the very end, please set it on the counter by the police officer. And that way we'll know that it's completed.
Okay, and it's your testimony that those bruises were from some type of action Jawan took against you. Is that fair?
Yes.
Okay. How long were you in the hospital?
I don't remember.
You didn't stay overnight?
I think I did stay. Nope, I didn't stay overnight that day.
Okay.
Nope.
But you were treated by some doctors. Is that fair?
Yes.
Okay.
They gave me pain meds. They took my statement. Gave me fluids. So I guess I was dehydrated. And they sent me home.
Okay. And what'd you do when you got home?
I was probably high off the pain meds.
Sure.
So I went to sleep.
All right. Okay. I don't have anything else. Thank you.
Cross-examination.
Thank you. Victoria, good morning.
Good morning.
It is still morning. My name is Brian. I represent Jawan. Before I get started, I don't want you to tell me the whole thing, but does your phone number end in 3310?
3310?
Yes.
No.
No. Okay. Do you know of anybody that does have that phone number?
No.
Okay. What does your phone number end in?
1096.
1096, okay.
I mean, it could have been, is it a long distance number at the beginning?
You mean a non-989 number?
Yeah.
No.
Okay.
Okay, that's
Oh, I
fine.
don't remember that number.
All right. Did you ever have a different phone number?
I have plenty of different numbers. I just don't remember all of them.
Okay, all right. So I want to just kind of get a little bit more history and background as it relates to you and Joanne. You guys were together for about 5 years, is that correct?
Yeah.
Okay.
Yes.
Do you have any children in common?
I lost my child, but yes, we did.
Yeah, I'm sorry. When was it that you stopped seeing each other exclusively?
We never really just stopped seeing each other. It was always an off and on relationship, even when we stopped being in a relationship.
Okay. And you use the term stop being in a relationship. So what does that mean?
Not boyfriend and girlfriend.
Okay. So you guys kept in touch.
Yes.
And would see each other.
Yes.
Put it bluntly, you'd hook up.
Yes.
All right. That continued for some time, correct?
Yes.
And at that point, the two of you were not exclusive.
Not in a relationship. Yes.
Well, what I'm asking is, if you were seeing somebody else, he was seeing somebody else, that was fine.
I think he was seeing somebody else, but I wasn't seeing nobody else.
Okay. And would it be fair to say that it was sometime in March of 2020 when you guys ended the relationship?
Possibly, yes.
A little over a year ago?
Yes.
All right. You were asked, one of the very first things that you were asked was whether you were in a dating relationship, and you told us that it's complicated.
Yes.
You still feel that way today?
Yes. I mean, no, not really, not complicated. It's more so, I don't know. I can't explain it.
Okay. Do you think it'd be fair to say that you still have feelings for him?
I most definitely do.
I want to just go over what you indicated to us regarding how things happened. It'd be fair to say that in August of 2020, Joanne was seeing somebody else.
She's always seeing someone else.
Okay. All right. And it'd be fair to say that you weren't happy about that.
No.
All right. You spoke to the police officer. Actually, I think it was this police officer at the hospital. Is that correct?
I can't
Don't remember?
remember.
Okay. That's fair. But you did speak to a police officer.
Yes.
All right. You told that police officer what happened.
Yes.
All right. And do you believe that the story that you told the officer that night was accurate?
See, when I watched the video earlier, some of the stuff that I was saying was true, but then on the paper it wasn't.
Okay.
So like it was mixed up or somehow, I'm not sure, but.
Well, so you told the police that night that he was waiting on the porch, right?
No.
You didn't tell them that.
No.
So if that were in the report,
I say he was waiting, but he wasn't on the porch. It said it in the black and whites, but in the video it didn't.
but what do you mean by that?
Like when he recorded me talking and telling him what happened, I never said that he was sitting on the porch.
I see. Okay, so
It's just like maybe I'm not sure how he wrote the report up, but the black and whites wasn't all the way 100% true.
when you say the black and whites, you're talking about the written report?
Yes.
Okay. So if it says, if the report were to say that he was on the porch, you're saying that that's not accurate.
Right.
And the, when you spoke to the police that night, did you tell them that you guys were inside?
Yes, I think, not positively sure.
Okay, you
I said
never-
a lot of, I said a lot of stuff, to
Said a
be
lot of stuff,
honest,
okay.
yeah.
And did you say that that he grabbed your hair when you were on the front porch or the front steps? If you know. Yeah, sure.
Not sure.
Okay. All right.
Probably did. 9 times out of 10, I probably did say it, but it was more so when we was in the house.
Okay, well, let me ask this. When he got there, do you know why he was there?
Probably to come get his stuff. He had a couple things at my house.
Okay. So were you expecting it or?
No, I never, no. He just pull up when he want to pull up, which I don't mind.
Okay,
It was never bad vibes when he pull up, but sometimes I just get irritated and don't want to talk to him.
okay. So when he was there, I just wanted to make sure I was clear, because you said pull up. On August 19th, you indicated he was already there though.
Okay,
Well, I want to make sure that that's correct.
okay. I don't remember.
Okay, so
I probably said it, but then I'm not sure, so I can't say.
that's fair enough. Argument started over him cheating.
Or him seeing somebody else.
All right. And did you know who that was?
I know a few of them.
A few of them. Okay. And I just want to make sure that I understand exactly like how this progresses, because you're telling us that he was there to get his things because he had a few things still at your home.
Mm-hmm.
Jenny, yes?
Yes.
Sorry about that, Judge.
Sorry.
And it ended up about him seeing somebody else.
Yes, I don't know how it progressive, to be honest.
Okay,
Deep. I can't remember how it progressive,
okay.
but yeah, I can't really remember everything. It's almost a year ago. Can't remember anything.
So do you know whether or not you started the argument or he started the argument?
Probably me, because I'm always wanting to know why. So
I
9
see.
times out of 10, it probably was me, because I want to know why you cheated on me or why you lied to me. So 9 times out of 10, it probably was me.
How did it escalate into a physical altercation?
I can't remember.
Do you know if he struck you first?
No, probably I pushed him.
Okay.
Probably telling him to leave, so I probably pushed him out the house.
So you're saying that the argument itself started while you were in the house?
Yes.
Now-
We ain't argue outside, not that day, no.
I see. Okay. But you didn't tell the police that?
No,
Okay. You have a cousin that lives with you as well, correct?
not anymore.
Well, at the time, right?
Yes.
Okay. And I took a look at your cousin's name, and I think could you just tell me what it is?
Jakia Hughes.
Jakia. Got it right. So Jakia was living with you at the time,
Yes,
and do you know if he was home?
yes,
So he was in the house when this all happened.
yes.
All right. Do you know if he spoke to the police?
No, he didn't.
Okay.
But I don't necessarily think he heard anything either, because he always walks, when he gets off work, at the time he worked with me. So when he get
Okay.
off work, he has his headphones in and walk around the house. So I don't necessarily know if he heard or anything. And
So you're in an apartment, right?
yes,
So tell me about the size of the apartment. Is it 2-bedroom?
it's 2 bedroom, 2 bath. It's 3 floors, a basement, main floor, and upstairs.
So it's a townhome?
Yes.
All right. Do you know where Jakia was?
Probably upstairs. He just got off work, and he usually take a shower when he get off work. So
Okay.
he probably is upstairs.
And I'm just kind of remembering this, and this doesn't have anything to do with your story, but how do you spell Jakia's name? Just so we have it for the record.
Jakia.
Okay, all right. And you believe that Jakia would have been upstairs during this whole time?
Possibility if he got off work when I got off work.
Okay.
He usually takes showers before I take showers, so.
You and Joanne would have been loud, right?
Not really, because the neighbors are nosy. So. No.
Okay, that's fair enough. Before this, when was the last time you had seen Joanne?
Before August is probably a month or two.
And between March and August, about how many times do you think you were seeing him?
A lot.
A lot. Okay. Do you think it was more than once or twice a week?
Yeah, I can say yeah.
Things kind of fall off after a little bit of time.
They don't never fall off between me and him.
Okay. All right. You went to the hospital and they gave you, you said, pain meds and fluids, correct?
Yes.
Sorry. Yeah. Did they diagnose you with anything?
Not that I can remember. Bruised ribs.
Okay.
And a concussion.
Okay. Did either of those things cause any problems for you?
No.
Okay. You received the two things, the pain meds and the fluid. Do you know what kind of pain meds those were?
Dilaudid through the IV.
So they gave you some good ones.
Yeah.
right.
That's it. I probably was asleep when I went home.
All right. Do you know if you were able to drive yourself home that night?
No, I think I called the cab.
Called the cab. All right. Didn't have any lasting effects from those injuries?
Nope. No.
Okay. And beyond what you took a look at in those photos, no other issues?
No.
Okay. Did the doctors do any treatment beyond the Dilaudid? Did they wrap your ribs, or did they have to do any other treatment that you're aware of?
No, they took my blood work. But that's it. I don't know why they said blood work, but they took blood work.
They didn't come back and say, hey, you've got something in your blood that we're concerned with because of this?
Nope.
All right.
No.
Did you ever talk to your cousin?
Yes.
Like, did you tell him what was going on, where you were going, or anything?
Going as in
That
to
night.
to when I went to the hospital?
Yeah.
No, I barely we smoke and that's about it. We go our separate ways. He
Oh,
stays.
okay, so
Yeah.
You guys aren't real close.
I mean, we're close, but we don't talk about relationship wise.
Okay.
Like we just smoke and that's it.
Kind of hang out.
Yeah.
Okay. And then when you asked him to leave, he left?
Yes.
Joanne?
Yes.
Did you have an opportunity to review the police report?
No, just a little bit of what they were reading, why prosecutors was reading to me. And that's when we had to watch the video because some of the stuff that was in there I didn't remember saying.
Okay.
And when we watched the video, it showed that I didn't say it.
Okay.
So
Are you, and I just want to make sure because I didn't quite catch it. You said the video showed you did not say it?
yes.
Got it.
Some of
Okay.
the stuff that was read off,
was-
like the kicking and the bruise, like,
Mm.
or some of, I can't remember.
Okay, all right. Victoria, do you even want to be here today?
No.
Did anybody threaten you about your testimony?
No.
Tell you you better come in and try to help him out or anything like that?
No.
Okay. As far as the testimony you're giving today, you believe that is accurate in terms of what happened?
Yes.
All right. Let me have one moment, Your Honor.
Okay.
Victoria, do you believe that your injuries were serious?
No, but I was in pain.
You were in
But
pain?
no.
Okay. Victoria, thank you. Nothing further.
Any redirect?
Yes, just briefly. I won't keep you too much long, Victoria. I know it's not an enjoyable experience, I'm sure. You still had to go to the hospital though. You felt like you needed to go to the hospital,
Yes.
and they gave you Dilaudid. That's not Tylenol or ibuprofen. I mean, that's doctor has to give you that through an IV, no less.
Yes, because I didn't want to take the pills.
Sure. But you felt that it was serious enough. You had bruised ribs.
Yeah, I was in pain. I didn't know I had the bruises until they took the pictures.
Sure.
But I was just in a lot of pain and I couldn't even sleep. So, yeah.
So you needed to be treated.
Yes, I guess so.
Now, I know this was a difficult time for you, but you said you lost a child.
Yes.
Was that Joanne's child?
Yes.
Mr. Jean, to talk to you about the video. I think you had some trouble recalling some things. Is that correct?
Yes.
And I suggested if you see the video, it might refresh your memory. Is that correct?
Yes.
And it did. It helped you.
Yes, I remember me being in the hospital. Yes.
Okay.
I remember talking to the police officer. I just don't remember which police officer.
Sure. It was a while ago.
Yes.
Now, Mr. Jean, to talk to you about your statement made to Officer Hager.
Yes.
At the time, did you tell him Joanne's name?
No.
All
I
right,
lied.
tell me about that.
I didn't want him to get in trouble at all, so I lied about the name of who it was. I made it all up.
So if you were trying to get back at him or get some revenge for him cheating, probably would have told the officer his real name.
Yes, but I didn't because I didn't want him to get in trouble at all.
Obviously, the officer figured out it was Joanne.
I don't understand how he found that out, but he did.
He's an investigator. What name did you give? Do you remember?
Jonathan.
Okay. And what last name?
I don't know. Can't remember.
Okay. It's probably on the video.
Yeah.
All right.
Yes.
All right, nothing further.
All right. Do any members of the jury have questions? If so, please raise your hand. Do not ask them, but I would need to take a look at those. I see no hands raised. At this time, may this witness be excused. Mr. Shawinski?
Yes, Your Honor.
Do you agree, Mr. Jean?
I do.
All right, ma'am, you may be excused. Mr. Shawinski, that clock's about 5 minutes fast, but if we're going to take a break, it seems like we would take a break now for about an hour and then be able to reconvene.
Seems reasonable. I'd have one additional witness and
One additional witness to the officer?
No, I'm sorry. I'd have
Just the
officer
officer.
testify. Yes, correct.
Okay, so just one more witness.
Correct.
Mr. Jean, any objection to us taking the break right now?
No, Your Honor. That's okay.
All right, so what we're going to do is give you a 1 hour break, being mindful of Dima's circumstance, wanted to get the case done today, and I'm not doing it to embarrass her. I just want to make sure this happens. It's gonna be 45 minutes that I'd ask you to get back here. So if you would be back here by 9:45, that actually isn't about an hour. It's 11:49 right now. So if you could be back in the jury room by 11:45, you're free to go anywhere.
12:45.
12:45, 11:45 would be 0 time, -4 minutes. So 12:45, if you could be back by that time. Please rise for the jury. Follow Ms. Jason to the jury room, please. All right, you may be seated. The record reflects that the jury is out of the courtroom. Before we break for the noon time break, Mr. Swinski, anything you'd like to place on the record?
No, Your Honor, the jurors did return plaintiffs 1 and 2. I will leave them with the court during the break.
Okay.
Because they are part of the record, but they did return those to my counsel's table.
Mr. Jean, anything you wish to place on the record?
No, Your Honor.
All right, we'll be adjourned then at this time. Thank you.
Thank you.